I have 12:30. We'll go ahead and call the meeting into order if everybody's ready. Before we begin, I would ask Chairman Nix, would he be willing to open our meeting with a prayer? I got him.
You push your button.
He's got it. I think he's over here. Should be it. Amen. Thank you, preacher. Okay, we're here for a hearing on House Bill 750, House Bill 809, and House Bill 824. And looking at the authors, I believe the fellow longest in the tooth and with the most seniority in this group would be Chairman Smith. Are you ready to present your bill? All right, well, proceed, sir. Up here probably. I think they like to do that because of the recording and the cameras and whatever all.
Is it because I have seniority or I'm just old?
Whichever makes you feel better.
Thank you, Mr. Chairman and members of the committee. I bring to you House Bill 824. House Bill 824 clarifies that a variety of routine fees for banking services offered by state-chartered banks and credit unions will not be considered interest. The bill covers a range of common deposit account fees, including overdraft fees that are agreed to in writing between the depositor and the financial institution. The bill simply confirms the law that we have understood for a lot of years. Deposit account fees are in fact fees, not interest. Now the next statement I want to give you is really important. It says, the bill ensures banks and credit unions operating with a charter issued by the state of Georgia are treated the same as banks and credit unions operating with a charter issued by one of the federal agencies or other states. Fees charged by these federally or state-chartered institutions are not considered interest under federal laws or any other state. Federal laws and rules expressly state such overdraft fees and other deposit account fees are not interest for those financial institutions operating in Georgia with a national charter. The bill removes any ambiguity about these same fees for Georgia chartered institutions. The bill creates parity between state chartered and federally chartered banks in Georgia. In other words, House Bill 824 creates a level playing field. In July 13, Commissioner Hagler issued a declaratory order stating that overdraft fees are not interest. The order applies only to state of Georgia chartered banks and credit unions, and the Commissioner can issue parity orders based on 7-1-61 of Georgia Code so that state chartered and federally chartered banks operate on a level playing field. And in conclusion, without this legislation, families and businesses that have chosen to do business with state chartered institutions may not have access to these services they have become accustomed to. House Bill 824 is needed to assure that Georgia chartered financial institutions do not have to operate at a competitive disadvantage. Another important point, no other state in the country has these restrictions, and neither should Georgia. Point of interest, of the 159 counties, 59 of those have no federally chartered banks. Mr. Chairman and Committee, I ask for your favorable consideration of House Bill 824.
Thank you, Mr. Chairman. Do we have any questions from the committee for Chairman Smith concerning House Bill 824? Just press your button if you're not in rules. I don't know how that works. No questions for Chairman Smith on that. Oh, I'm sorry. Mr. Flood.
Thank you, Mr. Chairman. Chairman Smith, I understand the intent of this bill. Right now, federally chartered banks and credit unions do not consider overdraft fees as interest.
Correct. That's federal law.
And essentially, what we're doing is making sure that those institutions that are chartered by the state of Georgia are treated exactly the same.
Yes, sir. You're exactly right.
Any further questions? No more questions for the chairman. Give me just one moment. I had asked the author of the bill, due to some scheduling. Now, we had said prior to this meeting that we were not going to vote on a bill. And if there's objection from the committee, we will postpone the vote until tomorrow on House Bill 824. But I would ask the committee to consider voting on that bill at this meeting. But I would ask if there is objection. If there's objection, we'll vote tomorrow like I had said we would. Is there any objection to voting on House Bill 824 today? No objection. Okay, well then we will, if I have a motion. Mr. Chairman, It do pass. Is there a second? Is there any more discussion, any further discussion? Those in favor of House Bill 824 will signify by yes by saying aye. Aye. Any opposed, no. The bill has a do pass recommendation.
Thank you, sir.
Mr. Chairman.
Thank you, committee.
At this point, I will recognize the Vice Chairman, Representative Williamson, to present House Bill 809. Vice Chairman Williamson.
Thank you, Mr. Chairman, members of the committee. Today I bring before you for your consideration House Bill 809. This bill would amend our Fair Business Practices Act of 1975 to prohibit the bad faith assertions of patent infringement claims. Well, when I first got in the General Assembly, my good friends always, on both sides of the aisle, asked me the first question I would hear is, what's your bill do? And what I'd like to tell you today is why we need this legislation, and then I'm going to tell you what it does. But for the last several years, the nation has seen a proliferation of patent infringement claims. These are commonly called patent trolls. It's sort of a derogatory term, but according to Investopedia.com definition, I'm going to quote what this means. This is a derogatory term used to describe people or companies that misuse patents as a business strategy. A patent troll obtains the patents being sold at auctions by bankrupt companies that are attempting to liquidate their assets, or by doing just enough research to prove they had the idea in the first place. They can then launch lawsuits against infringing companies, or simply hold the patent without planning to practice the idea in an attempt to keep other companies productively productivity at a standstill. So that is this definition of what a patent troll does, but how do they operate? These patent trolls actually assert claims through vaguely worded demand letters that, and what they were hoping for is a quick settlement with the businesses to whom they're targeting these demand letters. Small businesses are particularly vulnerable to these tactics due to the lack of financial and legal resources, and more often than not, they feel forced to settle. So, you know, the next thing I would want to know, had I not researched so much this bill, is, well, give me an example of our Georgia businesses being effective. And anything that's happening in Georgia, you can multiply it by 50 because it's happening all across our nation. So in particular, Georgia businesses have received letters and emails, which the demand letters are oftentimes sent in the form of an email. And they're demanding that our Georgia businesses pay a license fee for technology that they're currently using. Sometimes it's as simple as converting an incoming fax to an email attachment. Another example, and it affects businesses that I've invested in, that demands a number of our small community banks pay for a license fee simply to cover the way that covers the way their ATMs are connecting to the internet. So the demand letter is alleging, in this case, of community banks, and it could equally affect our credit unions in Georgia, that because of the way these ATM machines are physically going into the internet, there's some sort of technology going on that the bankers wouldn't be aware of, or the credit union board of directors wouldn't be aware of, that is allegedly being infringed upon by the way this process works. One industry that, during my research, is particularly hard hit is the digital printing industry in Georgia. It turns out that owners of these patents are alleging infringement covering these quick response codes, these QR codes, the little funny looking, little puzzle looking things, square things. As my kids have sort of educated me how they work, but they're on almost all of our products and things we buy in the stores now, and oftentimes the printers, or at their customers' request, are putting these QR codes on merchandise. And then in turn, our high-tech digital printing industries are getting hit with patent assertion claims that, or assertions of patent infringement claims that the codes they're using, the scanning, the computer-to-plate workflow that the printers are doing, and their online ordering systems are infringing upon patent holders. Well, almost inevitably, they're vaguely worded assertions. And what this legislation would do would attempt to stop the bad faith assertion of patent infringement claims. Would in no way, shape, or form stop any legitimate patent holder from protecting their intellectual property, or those processes or technologies or parts or whatever that they've invested in the product, patented it, and would no way, shape, or form stop their ability to protect their patent. One thing I wanted to point out was that most of the targets of these patent infringement claims are small businesses. We're talking about $10 million of revenue and below, down to the mom and pop hardware stores on Main Street. One Boston University study showed that 90% of the companies sued by patent trolls were small to medium-sized technology companies, and they estimated that $29 billion in patent claims were incurred in the year 2011. And the problem's only gotten worse in the last 3 years. So, real briefly, Mr. Chairman, if I may just walk everyone through the bill line by line. No, well, not every line, but just going to skip to the highlights. So, this legislation shows in line 25 that a person shall not make a bad faith assertion of patent infringement. Now, a court's going to consider what a bad faith assertion is in the demand, if the demand letter fails to contain the next three lines I give you, which is line 29. The assertion's going to have to include the patent number, The assertion will have to include the name and address of the patent owners or assignees. And in line 32, the demand letter is going to have to include the factual allegations that are concerning the specific areas in which the target's products, services, or technology have been infringed. In lines 34 through 37, you'll read that if the patent owner fails to conduct an analysis comparing the claims in the patent to the target's products, services, and technology, they will have to specify in their demand letter how the target, the business is getting sued, is actually violating the patent. And none of these demand letters are doing that now. They're just vague assertions. Again, it's fishing expeditions by these patent assertions entities that are trying to milk money out of legitimate businesses, basically through a series of intimidation letters. Now, before I conclude, I want to stress that this in no way, shape, or form stops the legitimate protection of patent holders. In fact, lines 64 through 65 says very clearly, the author of the demand letter is not going to be considered a bad faith claim if the author of the demand letter makes a substantial investment in the use of the patent or in the production or sale of a product or item covered by another patent. In lines 66 through 77, it's not going to be a bad faith claim if the author of the demand letter is actually the inventor or original assignee of the patent. If the owner of the patent is an institution of higher learning, and folks, that's what our Georgia institutions are all doing. They, when a process or technology comes along, and anyone, I won't start naming them because I'll miss somebody, and I don't want to do that. But if the idea bursts out of a Georgia institution of higher learning, and it is something that the university chooses to patent, that's protected, even if it's sort of parked for a while, because that is research that's derived from a university that is not going to be a part of any kind of bad faith effort. It would be, by the definition under this bill, would be excluded from any bad faith allegations. And finally, any businesses that are asserting a patent infringement claim, if they've previously demonstrated good faith business practices in efforts to protect their patents, they're going to be excluded from a bad faith action. So at the end of the day, the court's going to decide if, in fact, the court looks at these series of steps that we're going to require, that hopefully we will require through the steps in this bill, that if it is, in fact, if the target has sufficiently convinced the court that they are the subject of a bad faith patent assertion claim, then the court at that point in time could make the patent holder put up to $250,000 bond to cover the legal defense in the event that the target is in fact held to be innocent of the claim. And what we believe, and other states believe, is that by putting these bad faith steps in, these high bar for these folks to hop over, that it will stop this, quote, patent trolling and this extortion racket that our businesses are falling prey to. So with that being said, Mr. Chairman, I'd be happy to answer any questions the committee might have.
Thank you, Representative Williamson, and we will do that right now. If there are any questions, Representative Smith, I believe, has a question right out of the chute.
Thank you, Mr. Chairman. Just have two short questions.
If you'll push your button, Representative Smith, and use that, I think they, again, like for us to use these things when.
Got to push it on the desk.
There you go.
Okay, I'm live now.
You're live. You're in room.
Thank you. Just two brief questions. Under Article 20, well, how you doing first?
Fine,
Good.
Representative Smith.
Thank you, thank you. Under Article 27A, going over to the second page, numbers 29 through 52, do we have anything on record, or is this the first that we've seen of this, or is this the actual record of what is on the books now for these patent infringement opportunities?
No, this would be brand new for our Georgia code. What we'd be doing is this would be actually amending the our Fair Trade Practices Act of 1975 to include, which is would be in this legislation would be administered through the Governor's Office of Consumer Affairs. Where you see the Governor's Office of Consumer Affairs is handling other bad faith type business practices. That's why this doesn't have anything to do with patent law in particular. We're talking about identifying people that are bad actors, applying, implementing bad faith. I can't have to use the terminology in the bill is just bad faith assertions. Because they're going, all they're doing is going on a fishing expedition. They really don't want to end up in court. They want to sort of terrorize a small business owner, get some licensing fees if they can, or settle quickly. The fees that ATMs were getting hit for by some of the financial institutions up in the Northeast was anywhere up to $5,000 per ATM. Well, a little regional bank that might have, 50 ATMs, that's a significant hit to their bottom line.
Because this is pretty significant, so there's nothing on the books pertaining to this, 28 through 52?
No, sir, not to the best of my knowledge.
And the last question, number 98, exemplary damages, would they be deemed as being punitive, or I'm trying to get a differentiation between exemplary. Is this punitive? Is it exactly what is this?
I'm going to have to defer to some of my legal colleagues there, Representative Smith. I do not know the answer to that question.
Okay. Thank you.
Okay. I'm sorry. Representative Strickland.
Thank you, Mr. Chairman. Representative Williamson, I have one question. The motion that's referenced in paragraph 79, help me understand, that motion would actually be filed in an action for patent infringement. It couldn't be filed just when you get a demand letter. You couldn't go file a motion with the court at that point. Is that correct? It would take a demand letter and then an actual patent infringement case. The motion could be brought in. Am I understanding that correctly?
I would, again, Representative, you're an attorney and I'm not, but I'm assuming that's the legal steps involved. Okay. At the end of the day, as a business guy trying to explain to attorneys those steps, I'm not very good. But what this does, as I've been assured, is it sets up the mechanism to stop the bad actors, thereby protects Georgia businesses.
Okay, thank you.
Who are we looking at? Representative Frazier, you have a question?
Yes.
There you go.
Thank you, Mr. Chairman. Representative Williamson, can you give me some stats on fees that have been charged in the past that warrants this bill? Because you have had to have someone talk.
Some examples?
Yeah.
And
I'd like to know the cost. I mean,
yeah. Well, again, according to this study done by Boston University, the cost back in 2011 was, in fact, according to Boston University's estimate, and I'm sure there were legitimate patent infringement claims in this bucket of money, but it hit $29 billion was their estimate, billion, in 2011 out of the because of business litigation claims. So this truly is a bipartisan issue. Vermont, this is based on national Council of State Governments legislation. Vermont just passed this. Our friends out in Nebraska are passing substantially similar legislation. And it's my understanding that this very, very similar legislation is working its way through 13 additional state legislatures right now. It's just reaching almost a crisis proportions the way these claims are hitting our businesses. So, but speaking back to, I was trying to give some examples how Georgia businesses are being hit. But again, as far as ATMs, anywhere from $2,000 to $5,000 licensing fee per ATM location. And these letters never tell you exactly what you're doing wrong. You can't fix something when it's just a vague assertion. So they threaten the small business that, hey, if you don't send us this money, we're going to sue you. Well, then the business owner goes to their attorney, and the attorney says, I think you can win this, but it's going to be a lot more than $5,000. You might as well pay them the $5,000 and make it go away rather than go to court and incur substantial legal fees.
Thank you. Do we have, Mr. Chairman, do we have any, I'm hoping that we have someone here that can testify to some of these fees. I'm very interested. You're not able to give me the
we have several speakers of the bill.
Yeah.
Right.
Court
But
bill, if you want
am
to.
I misunderstanding your question, Representative Frazier? Because when you say fees, these are demand letters that various businesses are getting, and it could be $1,000 per scanner in a business, or set amounts for another process that might be going on in the business that they're alleging that they have a patent on. And again, all our legislation is doing is when that demand letter comes to the business you represent over in Burke County, or it's Burke County, right, and others, surrounding counties, when they get this demand letter, it's got to say who owns the patent number, who owns the patent, how to get in touch with them, and specifically, what is that business doing to infringe the patent? Now, you've got Vogel over there. They've got enough money that they can just hire a bevy of lawyers and steamroll them, but the high-tech farming operation over there might be getting the demand letter because of the kind of technology they're using in their broiler houses or whatever, and they're not going to have the money to fight it. And that's indicative of the kind of, they'll roll in with a very vague patent and just target industries all throughout the country, and Georgia businesses are beginning to hit. They're strategic in the way they do it, and I've read a lot of articles substantiating the information I'm trying to share with you. They'll go into community banks in this area, and not in Georgia and South Carolina at the same time, but they'll skip from Vermont to the Midwest to Georgia, because they're trying to run under the radar before a lot of similar businesses get together and fight them as a class action, for example. So, but yes, the chairman's correct. We do have some expert witnesses here that would be happy to share some help, hopefully answer some more of your questions.
Representative Kelly, you have a question, comment?
I do, and I'll be brief here, Representative Williamson. What I gather from lines 24, down to 54, is basically, and I may be, speaking against my own interests here as someone who's in law school and going to be out needing some legal clients here before too long.
Don't you worry, you'll have plenty to do.
If you, any entity that would have a valid claim for a patent infringement, before they could bring a lawsuit forward, they have to plead in a complaint with some specificity. It seems like what you're asking for in lines 24 through 54 are just requirements that they would have to put forward in a complaint if they were going to move forward. What we're talking about here is just not asking the institution or another small business to have to go put an attorney on retainer just to file a motion for summary judgment, which when these patent trolls file a complaint, it would be thrown out through a motion of summary judgment if they went and they didn't have more information. This is just preventing that step from ever needing to go forward, making them spend the money that they would typically be pouring back into our community some other way.
Right, that's correct. Is any business owner, the first time they receive a letter from an attorney, those get open first, that and the IRS. And they go, because I won't say, they have similar opinions about both organizations, or both groups. So those letters get open, and when you're all of a sudden, the business owner has got this allegation. They don't even know what they're talking about. They run to the attorney, and the attorneys go, I don't know what they're talking about either, but it's going to cost you a lot of money to find out and settle it if you want to. And the good attorney is going to figure out a way to help you get out of it, but it's not without a cost.
Thank you. Representative Harden, did you have a question?
Thank you, Mr. Chairman. And Representative Williamson, I guess the items that you list as being a violation of this act, is that a compilation from other letters that have been sent before, or where did these factors come from?
Now, you're talking about in lines 25 through the end of, well, we're on beginning of line 24, 10-1-771, subsection B. Everything outlined in subsection B is what the patent needs to include in their demand letter, or if it's not included, they have to make a good faith. They have within a reasonable amount of time.
All right, so if, and you list those things in line 28 through, I guess about 54 there.
Yes, sir.
But those items, are those letters before?
No, sir, that's specifically the problem is that the pharmacist in, down in South Georgia where you represent, your peer down there, they get a letter saying that it appears that you're in violation of our patent that converts incoming faxes to emails. And your pharmacist's computer system that might be the technology they're using, but they're not suing. The demand letter's not going back to Hewlett Packard or IBM or the big huge pharmacy software vendor. It's coming to the pharmacist. And they're specifically targeting the end users of these things, but they don't have the patent number. They might have a series of patents, but they don't target the exact patent number, who owns it, and how that small pharmacy is infringing upon the patent.
Well, I guess what I was after is this is not a complete list because you do leave it open for the court. Any other factor that the court wants to consider?
Absolutely. And line 55 says that a court may consider the following factors as evidence that a person has not made a bad faith assertion, and very clearly goes through that. At the end of the day, number 7, line 77, speaking to your point, says, in any other factor that the court finds relevant, that they would say this is not a bad faith assertion of patent infringement. This is a legitimate patent infringement claim. So the court has enormous latitude, but what we're trying to do in other states, many states are trying to make sure that the information going to the targets, the small businesses, has the information exactly how they're sending demand letters saying we want money, but not saying what you're infringing.
All right, so this is a civil suit, not a criminal suit, is that correct?
Yes, sir. It's not criminal.
Thank you.
Representative Coomer, is that you? Okay.
Representative Williamson, just a few questions about this I want to be sure about. Is there already some law on the books that requires this pre-litigation demand letter? If you know, and if you don't, I'm glad to ask
that question one more time, please.
Well, maybe I can explain the question and then it'll make better sense. I see we're talking about this demand letter and trying to keep from having bad faith assertions of patent infringement, but I didn't see in this bill anything that specifically requires a demand letter before filing a lawsuit. Is there some law somewhere else that requires that?
Not that I'm aware of. The whole thing is that and again, as a non-lawyer trying to describe this methodology, the business owner is not even aware of anything They don't get a phone call. They don't get a warning. It's always a demand for money. Hey, you're infringing upon our patent. We're not going to tell you which patent. We're not going to tell you how to get in contact with us. We're not going to tell you exactly how your patent's infringing upon your business operations is infringing upon our patent. But we'll go away if you send us $1,000. And a small technology company could be just right on the verge of a public offering, and they have all these reps and warranties in the business contract that they have to have everything clean, no pending lawsuits, everything's ready to go to the next level. And if you're the small high-tech guy in Atlanta about to sell your company, you're going to write a check for $10,000, whatever it is, to make these people go away, where your reps and warranties will be clear on that aspect to make the business go through. And that's another example of how they'll prey on you. They'll figure out who's most vulnerable, who's the most likely to pay, and send the letter.
Okay, so there's not a requirement that we know of there's nothing that would require a claimant to send a letter before filing a suit?
Not that I'm aware of.
Okay. So then the way I read the bill, help me to make sure I'm understanding this correctly. This demand letter comes, and it may or may not come before a suit is filed, but when this demand letter comes, the target can then make a claim based only on the letter being deficient?
No, it's my understanding that basically the target the pharmacy can petition, they're still in court, but can petition the court, say, listen, this is not a good frankly, now again, I'd have to ask, my legal friends. It's my sort of understanding of how the law part of it worked is that basically our pharmacist friend could throw it in the trash can because it didn't have these specific, didn't have the patent number, did not have the how this process was being infringed upon. So they're probably going to go to their attorney, but attorney's advice says, well, listen, they hadn't met the bar of the bad faith assertions of patent infringement legislation that Georgia has and is handled through the Georgia's Office of Consumer Affairs. The attorney is going to tell them all that at that point, and then they can either respond or wait to the next step. And then if the lawsuit does show up, because this is always threat of a lawsuit, the lawsuit does show up to the business owner, then they're in court. Then the court will look and say, hey, is Georgia law being complied with? Was this a bad faith action or not? And in all likelihood, it's going to be a bad faith action. The court can still allow it to proceed, but the court, at the court's discretion, can require up to a $250,000 bond. And the reason for that, frankly, it's a relatively low amount of money, is designed, this legislation, this model legislation that all the states, many states are looking at right now, it's just to stop this whole trolling process, this fishing expedition by these people with, that own a bucket full of very old patents and have it's capitalized through a little LLC. That LLC does nothing but send demand letters. That is their sole business practice. So it's designed to stop them, because if in fact the pharmacy owner wins, the LLC bankrupts. In most cases, there's no money there, but that's why the court would have the latitude to put up a $250,000 bond in place at the court's discretion.
Okay, I think I have a little better understanding. I may have more questions later, but moving on, I notice in lines 89 through 92, I guess really 89 to the end, where the enforcement piece exists, there's basically not a, you're not, it looks like you're not creating a private, separate cause of action for enforcement of this provision, but the only enforcement mechanism would be through the Governor's Office of Consumer Affairs. Is that correct?
That is my understanding.
Okay, and then just kind of get a little bit more. I don't want to be hyper technical, but if you look at line 93, where it says, "Upon a showing in any superior court of competent jurisdiction," I think my suggestion on that would be is that it should just say, "Upon a showing in any court of competent jurisdiction," because it's a little bit, because superior courts are specific courts in Georgia as
All right,
opposed
so help me with the.
I just strike the word superior in line 93. And the other part that is a little bit confusing to me is in line 98. Exemplary damages in an amount equal to $50,000 or 3 times the equitable total of damages. I'm not familiar, and I'm not a patent attorney, and I'm not an expert in every field, I'll tell you that, but I'm not familiar with the concept of the equitable total of damages. It's a term that I haven't seen before.
Representative Smith has already pointed out that I don't know what that means either.
Okay, well,
or maybe
I
it's
don't
Representative Frazier. I really, again, not being an attorney, that language, and we're using model language that came out of the Council of State Governments, and that might not be the best language to have for the state of Georgia.
Well, I just would like to be assured that equitable total of damages is the right language that you want in there, and I don't have the answer to that sitting here today. So, thank you.
Representative Flood, you have a question?
I have a clarification. Thank you, Mr. Chairman. Representative Williamson, I appreciate you bringing this forward. As I understand the bill and the intent of the bill is that the reality is that there are sometimes infringements on patents, and those infringements should be there should be awards for those infringements when they occur.
Absolutely.
This addresses those occasions where there is either ambiguity or just falsehood about infringement actually occurring, and small businesses throughout Georgia and the rest of the country are paying fees because they are in fear of having to go to court and paying even more to litigate these potential infringements, which are vague and unclear to them.
That is correct.
And so this is an opportunity to help those businesses by requiring any patent infringement demand letter to be very specific and clear as to what patent is being infringed, who owns the patent, and other details to assure that they are in fact the holder of the patent and the target is actually violating that patent.
That is well stated.
And I believe the intent of this is, in terms of the damages, is designed in exemplary damages means to essentially not only punish but to set an example, to discourage other patent trolls from engaging in this practice as well.
And that would be my assumption as well, but as far as the mechanics of the law, I would need clarification from an attorney to make sure that I understand exactly what that means, and I apologize for not having done that particular piece of homework.
That's it, Mr. Chairman.
I don't believe we have any more questions from the committee, but we do have some people signed up to speak on the bill. So,
Thank you.
And before I bring the first speaker, I owe an apology to 1, 2, 3 people. Joe Brandon, Steve Bridges, and Brandy Bickle were signed up to speak on House Bill 824, and Chairman Smith's presentation was so compelling, I just lost my mind and didn't recognize them. I hope you all were in support of the bill. But if y'all want to speak on that bill, or give your preference, I'll certainly recognize you to do that right now, those folks, if nobody has. Okay. All right. Now, on to House Bill 809. I believe our first person signed up to speak on that is Ms. Elizabeth Chandler. Here, you can have that one. No. Ms. Chandler, I think everybody probably knows you on the committee, but just for the record, state your name and who you represent.
I sure will. Thank you, Mr. Chairman. I'm Elizabeth Chandler, and I work with the Georgia Bankers Association, and we're fortunate to represent all size banks throughout the state, and a pleasure to be with you today. Thank you, Representative Williamson, for bringing forth this piece of legislation. It's become more and more of an issue for banks across our state. We first started witnessing what we call patent trolls in the Northeast a few years ago. And then about two and a half years ago, we had some of our small bankers started receiving these demand letters. So over the last couple of years, there have been roughly 25 banks that have received the letter saying, you are infringing on our patent. It's the way that your ATM connects to the internet, and that was it. And so in terms of information on the specific technology aspect of it, the letters would go on to say, we will grant you a licensing or a license for a licensing fee of $2,000 per ATM. And so if, in many cases, the banks had a lawyer respond to that letter asking for further information. Some did not respond. And in those cases, a second letter was received from the troll or the troll's attorney, and it would say, we didn't hear from you. Our licensing fee has gone up to $5,000 per ATM. And, oh, by the way, here's a copy of the lawsuit, 44 pages worth, that we're going to file against you if we do not hear back from you. So that's the situation in terms of banks throughout the state. And we saw this legislation pass last year in Vermont, as Representative Williamson referred to, and it's currently pending in 14 states, including Georgia. So it's something that our industry has certainly gotten behind, and hope that we can gain your support as well. Thank you.
Ms. Chandler, would you mind taking any questions from the committee if they
Be
had
happy
any?
to.
Does anybody have any questions for Ms. Chandler? Well said, Ms. Chandler. Thank you.
Thank you.
Oh, I'm sorry. Well, Mr. Coomer, I'm assuming he may get into the weeds with you on this legal, so
Right.
maybe I might have an answer to that question. Go ahead, Representative Coomer.
That's exactly what I want to ask about. Do you know if there's anything that requires a demand letter to be sent to a, as we call in this legislation, a target before litigation is filed?
That's the only way we've experienced it. That's where it's all began with banks. So requiring a demand letter, I don't know, but that's what has put the issue in play for us.
Okay. Well, the reason it gets important to me is because I want to make sure, and I support this, the proposal here, but I want to make sure we get it done in a way that is correct under the law. And the reason I'm having a little hesitation is because if we look at lines 79 through 88 that talks about filing a motion by the target and requiring bond in the court and so forth, that language would indicate that you would already be in litigation there, because you're filing a motion. You're not filing a new complaint. You're filing a motion against, you would presume, a party. And I'm trying to square that with the next section that talks about basically no private enforcement. And I don't mean to catch you off guard. I'm not trying to surprise you with my questions. And if you don't know, that's fine. I'm sure somebody in the room will tell us. But that's kind of where I'm trying to get to. Does that make sense? My question makes sense?
I think so.
Okay.
I'm not sure I have an answer, though.
Okay. All right. So I guess the basic question is, do you have to have one of these letters before you go to court? Is that required somewhere in law?
My assumption is that would be the case.
Okay.
Any further questions for Ms. Chandler? Ms. Chandler, thank you.
Thanks.
Mr. Chairman.
Yes.
Can that just be my standing question for all witnesses?
Yeah, I think that's need to get the question answered for you. Next, Sally Kilpatrick. Oh. If you'll just repeat your name and for the record tell everybody who you represent.
Okay, Mr. Chairman, members of the committee, my name is Sally Kilpatrick and I'm with the Georgia Chamber of Commerce. And on behalf of the Georgia Chamber, I want to express our support behind House Bill 809. We believe this bill gives the state the necessary measures they need to address bad faith patent infringement. This is an important and costly issue to our banking members, and we would ask for the committee's favorable consideration behind the bill.
Are there any questions?
And I do not know the answer
Ms.
to your
Kilpatrick, she's gonna, he didn't even push the button. I was watching him. Thank you, Ms. Kilpatrick. All right. Next up, maybe whoever answers wins a turkey. Steve Bridges.
Mr. Chairman, I'm afraid I'm not going to win the turkey.
All right. Well, just tell everybody for the record who you are and who you represent, and we'll let you off the hook.
I'm Steve Bridges. I'm with the Community Bankers Association, represent over 200 small community banks around the state. I will address that just briefly, Representative Coomer. I'm a non-attorney as well, and I'm not certain of this. But that may be actually something that's required in federal law under the patent procedures at the federal level. That would be my guess, but that's what that is a guess. And but it is the way that we have experienced this problem. Is we get the demand letter as it's already been described, and I won't go back into all of that. And as Elizabeth said, we started hearing about this 2.5 or 3 years ago. It seems to make its rounds around the country. Like we had a wave that came into Georgia maybe a year and a half ago or something like that, and we've had another wave that's come in recently. They kind of go, and move around the country. One of the things that I wanted to point out that, may or may not, have sway here in this group, but to show you the magnitude of this problem, the seriousness of it, and the overall magnitude, this was a very small thing in the overall State of the Union address, but President Obama actually mentioned in his State of the Union address, because there is legislation pending at the federal level. It's broader than this, and I think it's getting, frankly, my opinion is it's getting bogged down because of how, it tries to cover too much. Whereas this zeroes in on the demand letter issue. And, but he actually mentioned in his State of the Union address that this is something that needs to be addressed. So I think that's a pretty good indication of how broad the problem is and how serious the problem is right there. And I do want to just in closing, and I'll be glad to answer any questions if I can, but I want to thank Representative Williamson for bringing this legislation. It's something that we very strongly support with the community bankers, and it is a problem with not only our industry but many others.
Are there any questions for Mr. Bridges? Representative Smith has a question.
I just have one question, if you will. Thank you, and I'd appreciate it. Typically, who are the authors of these types of letters? Because, we have this information in receipt, but who typically are the authors of these types of letters that the banks receive?
Well, it's the patent troll, as is commonly to be known, these individuals that are, quite honestly, in my opinion, crooks. And so either they or an attorney on their behalf is the one that's sending that or is authoring that letter, is my understanding. I mean, I don't know if that answers your question, Mr. Smith, or not, but Representative Smith, but that's my understanding.
Mr. Frazier, did you want to ask a question? Okay. You want to ask me a question now or later?
Thank you. And thank you so much for that information. I was sitting over here thinking in my head the word you said, but I just wasn't sure that that was the appropriate word, but thank you for saying it. Crook. I'm trying to understand the demand process here. We have folks that send out demand letters, and this is all legal and binding. And I'm trying to understand, is it from the federal level or the state? These trolls, is this legal? It sounds like it's a racket, and they're preying on the small business people. So why don't we already have something in place that would stop that before it gets to that point where they have to try to get a lawyer and prove that they own these patents or whatever?
Well, I think, Representative, I think that's a good question, but I think we had not ever experienced this kind of a problem till the last 2 or 3 years. So, at least here in Georgia, to the best of my knowledge, in our industry anyway, we'd never had these kind of demand letters show up in our mail. So I guess they never realized there was a problem in the past, so they never tried to address it. Now that's may not be the answer, I don't know. But see, patents are not filed with the state of Georgia. There probably is some processes at the federal level that deal with this, but the lawsuits are sometimes, filed in state court. So we're trying to address this at the state level in regard to the state action that's being brought.
And do you think that on the federal level, they should know about this? And so we're having to have to stop it on every individual state has to stop it, although it's.
Well, again, a good observation. I do believe that it's being looked at the federal level in terms of possible legislation and so forth. But again, that's gotten bogged down, as many things seem to do up there. And what we're hopeful of is whether or not the legislation passes in Washington to deal with this, that in some small way, at least, to the extent that we can in Georgia, deal with it. I would like to see us deal with it. Now, we can't get into the patent law itself. That's federal law, okay? But I think we can deal with it as it relates to these demand letters where they're about to file a suit in the state courts.
Thank you.
Chairman Nix, you've got a question?
I do, thank you. My question is, we talk in broad generalities, we talk about these patent trolls. Has a patent troll ever filed a lawsuit in the state of Georgia?
I believe they have. I know they've threatened to file a lawsuit. Whether or not they have or not, I'm not 100% certain.
I could threaten to file a lawsuit, but you're innocent until proven guilty. And the only time it looks like a court would get into
Well,
if I'm illegal in the first place, I'm very unlikely to go to court.
Correct. But the problem is, as was very much pointed out by the author of the bill, is that frankly, it's cheaper for them to settle when you get this kind of letter. I mean, it's not right, Representative Nix, it's not right. But the advice they're getting from their attorney is, go ahead and pay them the $10,000 and get them to go away, because it's going to cost you a lot more than that to litigate this situation. So, these guys are pocketing quite a bit. In other words, everybody pays them $10,000 that they send this letter to, and they send the letter to, 10 folks in the state of Georgia. That's a pretty good haul. Then they go to South Carolina, then they go, wherever. I mean, you use the term racket. I would concur with that assessment. But, you know, I think that's what they're counting on. They're counting on the small business feeling like they have to settle. That's the whole scheme.
I believe that's it, Mr. Bridges.
Okay.
Thank you.
Thank you, sir.
Thank you very much. And oh, we did have another question. I'm sorry, I didn't. We have another witness in case you might want to ask Brandy Bickle.
Thank you, Mr. Chairman, committee. My name is Brandy Bickle, and I speak on behalf of the credit unions in this state. We were very enthused to see this bill introduced in the state legislature, so thank you to the sponsor of the bill as well as the many co-sponsors. Several of you are in the room, if not all. This is a big issue for us in Congress as an industry. It is a growing threat. It is one of those odd things where you just can't believe that you have to have a bill to make this situation stop. But unfortunately, there's a lot of bad apples in the marketplace that take advantage of intricacies in the law to extract money from businesses who are just using their ATMs or using their home banking software, or, you know, and these are things that, you know, from credit unions, they're not writing this software, they're not creating the ATM, but they purchase these things, and because they purchase them, they're using them. They're the end user. They're the ones that are being, you know, attacked by these patent trolls. So any bill that we could have here in Georgia, and this bill would do that, to make Georgia less attractive to these bad apples, these people in the marketplace taking advantage of a situation, is very positive. Numbers-wise, to fight a patent, you know, to say, wait a minute, this isn't correct, you know, it's $30,000 just to file, you know, to say, hey, I'm going to fight that. For a credit union perspective, you know, that's a lot of money, and that's money of our members that we could put to better use. So we applaud the bill, we applaud what it's wanting to do, you know, and we appreciate all the questions. Now, I do not have your answer, but I view it as it's an abuse of demand letters, and that's what this is. It's a predatory abuse. So thank you, and we ask for your favorable support.
Any questions for Ms. Bickle? Ms. Jordan, you want to say something while somebody's standing up here?
So you're saying, thank you, Mr. Chairman, Ms. Bickle, that people could have already paid that we don't know about just to keep it hush-hush. That's why I think the question came to me, that thought came to me when Representative Nix asked his question, has anyone filed? Well, people may have filed, businesses may have not filed simply because of the fact to keep it hush-hush and to keep the cost down that we'll never know about. Is that possibly true?
That's correct, and that is correct. And you as a business owner, whether you're a credit union, whether you're a bank, whether you're, you know, any business, and you have to make that choice. Is it worth it to pay the extra thousands upon thousands of dollars to fight this in court, or do I just pay the $5,000 and make this go away and keep plodding along my business? You know, from an ethical, you know, moral standpoint, you want to say, no, you fight it. You know, you stop these bad practices from happening. But at the end of the day, you do have to weigh the cost. And unfortunately, you would like everyone to fight it, to draw more light on this to Congress. But unfortunately, you know, you don't have big pockets like that in a lot of business, especially your small mom and pops. So thank you.
Thank you, Ms. Bickle.
Thank you, sir.
Yeah, I was just thinking, I knew that troll, that's a terrible word anyway. There was a children's story, I remember there was a troll, you know, a monster troll that sat under the bridge and was going to eat the little goat. And every time somebody says troll, it was a traumatic story to read to a 6-year-old. So probably what drove me into politics. Instead of something more. Okay, I believe that concludes our witnesses, and we will, on this particular bill, we're going to hear Mr. Fry's bill. We're meeting at what time tomorrow? Again, for everybody interested, 2 o'clock tomorrow to vote, if the author's ready, on that particular bill. Okay, now I believe we have Mr. Fry, Representative Fry, who is prepared to explain House Bill 750 to the committee.
Thank you, Mr. Chair. Thank you for giving us the opportunity to be educated on the serious business that you guys handle. Hopefully we can lighten it up just a little bit.
Aren't you an attorney?
I am not.
No, okay, never mind.
And I
you
don't
might
say
win
that.
some points by answering the. Okay.
Well, I mean what I say. That was extremely educational.
It was. Well, you go ahead, proceed. Didn't mean to say something ugly to you.
Thank you, members of the committee. This House Bill 750 will, in essence, alleviate the mortgage originating licensing requirements for bona fide nonprofits in the state of Georgia. We've worked really closely with Mr. Bridges from the community bankers and Ms. Bickle from the credit unions and the Georgia Department of Banking and Finance to craft legislation that will work out for everyone concerned. In full disclosure, I actually do work for a nonprofit that originates mortgages in the state of Georgia. This is the organization that everybody, I think, has heard of, called Habitat for Humanity. We build homes. We've been building homes for over 3 decades in Georgia, and we have 3 requirements that we utilize. And you have to have a need for housing, you have to have the ability to pay, and you have to have the willingness to partner. And the need for housing can be defined as something as simple as too much rent being paid. 50% is what we see a lot, 50% of your family income being paid. That's a need for housing. That's considered housing stressed. I actually have built a home myself. I am the licensed contractor for our Habitat affiliate in Athens. And I have built a home 5 years ago for a lady who didn't have running water, didn't have heat and air, and used an outhouse to raise her 1-year-old granddaughter in 10 miles from the city center in Athens, Georgia. So the ability to pay is decided through an application process, credit is checked, and jobs are verified, as well as rental situations to make sure the rent's being paid. Our homeowners are screened thoroughly, and personally in Athens, Georgia, I have 0 foreclosures. Across the nation, I believe we're at a 1 to 2% foreclosure rate. This bill is in reaction to the SAFE Act, which is federal legislation in reaction to all the housing crisis that we've experienced. And I don't believe was intended for the organization that we work for. Mortgage origination can be defined as simply discussing terms of a mortgage with a potential client. So when I sit there in my office and explain to a homeowner that they've been approved for a home before they start working with us to build their home, when I tell them that we have a 0% interest on a 25-year mortgage that will cost them $223.33 a month to own their own home, that is legally defined as mortgage origination. This will allow the Habitat affiliates in the state of Georgia to keep originating mortgages in that same vein. Not every affiliate has the same terms, but they're very close. And we would ask for your favorable consideration on this legislation.
Thank you, Representative Fry. Now, let me point out, and I don't know if you all, what Representative Fry is presenting is the substitute to House Bill 750. Do you have that? Okay, you do have that? Okay.
Right,
well,
I apologize for omitting that. Right.
No, I should have said that before you came up. I just wanted to make sure the committee members already had, because I think it was still pretty warm.
Right.
When the committee meeting started. Okay, are there any questions for Representative Fry concerning the substitute? Yeah, I see. I don't know who was first. It doesn't matter. This is a question. Yeah, any question. He was describing the substitute. So when I refer to are there any questions, I make sure we're looking at the substitute. Ms. Frazier.
Thank you, Mr. Chairman. Representative Fry, I just have one question. How many other states now have this exemption?
So I had the same question. I called Habitat International the other day and asked their federal person that works on issues like this and said, how many other states have this exemption as well? And she said to me, all of them. And I said, well, okay, that sounds fine. Just tell me how many really there are. And she said, 49. So we will be the 50th state in the nation to address this issue specifically like we're addressing it today.
Thank you.
Representative Flood.
Thank you, Mr. Chairman. And Representative Fry, I applaud you for bringing this bill to our attention. I remember a couple of years ago when we created these exemptions in the mortgage licensing bill, and it was apparently an oversight that we did not include the nonprofits like Habitat for Humanity. And I'm glad to see that you have a 0% foreclosure rate and are doing the kind of work, and I applaud this bill and would urge my colleagues to support it.
Thank you.
Okay. Representative Coomer, I believe, has a question.
Thank you, Mr. Chairman. In a few places in the bill, I noticed, and in particular line 26, I think it's the first place I saw it, there's a phrase, terms that are favorable to the borrower, and I saw that in a couple other places. Is that a term of art, or is it defined somewhere, or what does that mean?
I believe, now, Mr. Fears can correct me if I'm wrong, but I believe that is up to the administrative definition of the banking and finance department, where this bill allows them oversight into the definition of a bona fide nonprofit, allows them to have administrative ability to check the books of that nonprofit, and allows them to decide administratively whether that nonprofit meets the requirements outlined in this bill, where they can allow somebody to proceed, or they can stop them from originating mortgages as they see fit.
So that term's favorable to the borrower, that's defined somewhere in regulation? It's already in.
I'm not aware of a specific definition for that. Mr. Fears, can I ask if you are aware? Mr. Chairman, can I ask
Asking me if I'm... Yeah, I think you have to come up, and they'd like for you to and just identify yourself and tell me. You can share the podium with Representative Fry.
Thank you, Mr. Chairman. Representative Coomer, that's...
they'd like for you to identify yourself.
Oh, I'm sorry.
For the record.
Yes, sure. Bo Fears, and I'm with the Georgia Department of Banking and Finance. What that does, that provision, is the department is going to have to enact rules and regulations to determine what is a bona fide nonprofit corporation. And one of those things is, will the terms be favorable to the borrower? And that's something we'll fill in the gap. But that's structured on federal language.
So is there already federal language that defines terms favorable to the borrower?
What it does is it defers it to the states, and so it's going to be really something that kind of we adopt our regs and what we put in place. The other 49 states already have something that it's slightly different, and we're just going to have to figure out where we want to put it.
So we're going to leave that term up to what agency?
The Department of Banking and Finance.
Okay. Thank you.
Yep.
Are there any other questions for the author? We've got 3 speakers on behalf of the bill, or at least want to speak on the bill. Since they have Habitat for Humanity beside their names, I'm assuming they're supporting the bill. Oh, I'm sorry. I didn't. Okay. Representative Vice Chairman Williamson had a question.
Just one real quick question. Did you tell us what the consequences are absent this legislation to, in particular, Habitat for Humanity?
Potentially.
What's the harm done if we didn't address this issue?
If we didn't address this issue, there's 70 affiliates around the state of Georgia. A lot of the affiliates do not have employees, and they're nonprofits based on total volunteers. It will put an undue burden on these smaller affiliates and I say smaller, we're one of the largest in Northeast Georgia. Potentially, we could go out and get a mortgage originator with a bona fide license to step in. It would preclude me from being able to talk about the 0% interest in the mortgage payment to our potential buyers. But to the smaller affiliates, it would be devastating. You have a group of volunteers that run these habitats around the state, and they buy the land, they select the family, they build the houses themselves, and then they turn the mortgage over to the family. And that's a lot of work for a group of 10 to 15 groups of folks just to do on their own. So that would be, it's undue burden on these.
So we don't want President Carter to be a crook. That was a joke. Now it's well known. It's well known how he's supported the organization over the years. But the broader point is that, and I myself have been active and have worked on behalf of Habitat for Humanity in years past. And what you're saying is that these people that are wanting to improve their local communities, absent us correcting this basically technicality on behalf of Habitat for Humanity, is going to hurt the efforts to provide decent, safe, and sanitary housing through Habitat for Humanity in all the communities in Georgia.
Absolutely. And just for clarification, as far as we know, we are one of the few, if not only, organizations that do originate mortgages of this kind. We build the homes, we pick the homeowners, we check the credit, we originate the mortgages, we service the mortgages. We're just a one-stop shop that started so long ago. And, you know, for the record, you have been very supportive of your local affiliate, and we appreciate that.
Thank you. No more questions for Mr. Fry. Because of the limited time, we've got 4 actual speakers on the bill. I would ask them to limit their time to 30 seconds to speak on the bill apiece. Now, the first person to sign up is Brinkley Pound.
Thank you, Mr. Chair.
Thank you, Representative Fry. If you'll give us your name and tell us who you're with.
Mr. Chairman and members of the committee, thank you for allowing me to be here today. My name is Brinkley Pound, and I represent the Columbus Area Habitat for Humanity affiliate, which serves Columbus and Muscogee County. It is one of 66 active affiliates in Georgia. Since 1984, our affiliate has constructed and sold and serviced 278 homes in their mortgages to hardworking Georgia families. In Georgia, over 5,200 homes have been sold. Last November, the Columbus affiliate held a mortgage burning ceremony where 15 families celebrated paying off their zero-interest mortgage and paying it off early. Thank you so much.
Thank you, Ms. Pound. Paul Brown.
Good afternoon, Chairman and member. My name is Paul Brown, and I work with Jackson County Habitat for Humanity in Jefferson, Georgia, and I also volunteer in Barrow County, which is right next door. Over the years, we've serviced 77 families, building homes and giving them a better place to live. This fall, just down the road here a few miles, we celebrated the 800,000th house milestone for houses that were helped worldwide with Habitat for Humanity. I'm asking for your support on this bill, which would help my work, since I am the only employee of our affiliate that has to build the homes and originate these mortgages. That would make my work streamline so much faster that we could help more families. Thank you again for your consideration.
Thank you, Mr. Brown. Next is Bob Boyd.
Thank you very much. Excuse me. Thank you very much for letting me speak on behalf of House Bill 750. I'm Bob Boyd. I'm the Executive Director of Habitat for Humanity in DeKalb County. Today I'm representing the 7 or 8 Atlanta Habitat affiliates that are in the greater Atlanta area. And all of us, like my friend in Athens, have great stories to tell about homeowners. And I'm not going to mention that today, but I did want to let you know that many Habitat affiliates have restores, which is similar to a Goodwill store. The difference is, in a restore, we sell new and used surplus construction materials. And I think it's important for you all to know that nearly $1.5 million in sales tax has gone back to the state of Georgia through state revenue. I appreciate you all's support of House Bill 750, and thank you very much.
Thank you, Mr. Boyd. And Harold Tessendorf, did I get that right?
Yes, sir.
Okay, you can say it again and tell us who you are.
Good afternoon, members of the committee. Mr. Chairman, thank you very much for the opportunity to speak in support of House Bill 750. My name is Harold Tessendorf. I'm the Executive Director of Macon Area Habitat for Humanity. Since our affiliate's inception, we have served 98 families in Bibb and Jones counties here in Georgia. And this year we plan to serve another 10 families through our efforts. Together with the other, my affiliate, joining with all those others that have been mentioned around the state of Georgia, our impact, our combined impact on Georgia's economy since our inceptions has been close to $3 billion. So once again, we want to thank you for your support of this bill. We want to thank you for your support of Habitat and providing affordable home ownership opportunities in your communities. Thank you, sir.
Thank you. I believe that concludes our speakers. Again, we will reconvene as a committee tomorrow at 2 to consider House Bill 750 and House Bill 809. I appreciate your patience. It was a long meeting, but very informative. This meeting's adjourned.